My friends, when we were studying this law, this legal services or legal services authority is concerned or legal services act is concerned, we were having only 10 marks. That too in the law of pleading and conveyance. A student can assume what importance can be given to a subject wherein only 10 marks has been given. 90 is other conveyance, pleading and other things. So we used to think that no, we can, that is, get the passing marks in other and least bothered about this legal services authorities. But nowadays, the legal services authority or legal services act is concerned that it has got a significant developments and much importance has been given to this. There are various reasons for this. If you see the statistics of pendency of the cases before various courts, from top court, Honorable Supreme Court to the Civil Judge Junior Division, more than 4 million cases are pending in various stages. If you want to dispose of those cases by adjudicatory method, by holding a trial and writing a judgment, even 5 decades without adding the new cases, so it is required. What we say, so here justice delayed is justice denied, justice hurried is justice buried. So how to dispose of these cases? So in that light, if you see Article 39A of the Constitution of India, it provides that state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way. In that light, the Legal Services Authority Act of 1987 has been passed, and this concept ensures that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. So one more that is aspect which I want to draw your attention is Article 14 and Article 22. So if you take Article 14, so it is obligatory for the state to ensure equality before the law. Nowadays, if you take this legal system, so here, who can afford a, that is justice, if you look into that aspect. So here, those persons who are able to engage an efficient, intelligent advocate. So if an advocate that who is having intelligence and seniority, if you want to appoint him, then you want some money. So whoever is having economic power, that he will get a justice, and poor is going to be denied because he is not able to give the fees, so which is going to be sought or asked by this particularly the advocates. So in that light, so here the provision has been made under Article 14 that it is obligatory on the part of the state to ensure equality before the law and legal system which promotes justice on the basis of equal opportunity to all. In that light, Legal Services Authority of 1987 has been passed to provide free and competitive legal services to the weaker section of the society in India. So my friends, V.R. Krishna Iyer, a great jurist and the former judge of the Supreme Court of India, has said in one of the decisions, I quote, legal adjudication may be flawless, but heartless, but negotiated settlement will be satisfying even if it departs from the strict law. So here, if you read this particularly the statement made by Krishna Iyer, legal adjudication may be flawless if all the procedural aspects, if they are followed, there may not be any flaws in delivering the judgments. But it will not be having any heart. So here, how that this particular system has to be that is settled. So you take for instance, a particular person, a poor fellow, he is so much hungry. He is so much hungry. He asks so many persons that I am hungry, that give something to me. Nobody gives. So he goes nearby a bakery and he steals a bread. If in accordance with law he is adjudicated, so what it amounts to? It amounts to nothing but a theft. So the theft definition is moving a movable property without the consent of the lawful owner. So it amounts to, that is, stealing a property. So if he has been tried, so he is going to be convicted definitely. That's why that what we say. So it is heartless. We will not say no, you are so hungry that so he is very much that is a desire this particularly bread for the purpose of survival. That aspect is not going to be looked into. So that's why it is flawless and heartless. But what is that the best method is, if it is negotiated and settled, it will satisfy even if it departs the strict law. So how that it can be settled? So here he has taken a bread. So here if you sit and set, that is for the settlement either in the local or in the mediation or some other adjudicative method, the area systems so which are there. So under such circumstances what we can do is, no, that he has stolen a bread. It may be costing about 50 rupees. So ask him to work in that bakery for 1 hour or 2 hours and satisfy. That is how that the settlement can be made. But whether the court can do it? No. Adjudicated method it cannot be. So that's why in India, legal system is adjudicatory system. So here it requires any evidence and it requires in accordance with law he should be tried. So here if he that is adopt this particular system, definitely that he is going to be convicted. So that's why what we feel is settlement is the best way of that is settling the cases. So here if you take the history of this particularly the legal services authority and legal services act is concerned. So here major contribution has been made by Justice P.N. Bhagwati and Justice V.R. Krishna. They have stretched earlier that what was this legal system is or in a legal services authority system was. So here that it was very weak. Very 1% that used to be settled in Lok Adalats. Even Lok Adalat used to be held once in a while. So in that light, so here that this particularly the contribution for shaping up this particularly the legal services authorities and legal services programs is concerned. So here that these two persons have made very good contribution. So here, if you take what is the aims of this particularly the legal services authority? What is the aim? So here in this particular behalf, this to protect the rights and interest of the people. That is one. And to give the awareness. That is awareness to the people. So if the awareness is given, that it will empower you. What is your rights, what are your duties, and how that you can approach, where that you can get the relief and other things. So here, how to secure your rights. So very recently in Belgaum district that there was a flood. So flood relief has been given. So when a flood relief has been given, whether it has been properly given to or not is one question, and whether it has been given to the proper in need is another aspect. So in this regard, a direction has been issued by the Legal Services Authority to go verify and give awareness with regarding to how that they can get this particularly relief. So there will be damages to their house, damages to their fields, damages in various aspects. So here that has to be calculated, and so proper damages have to be paid to this particular victims who have suffered in that particular flood. In that light, so here that this particularly, so whenever you give this awareness, so then definitely that people will have an empowerment. So what is your stage when you have not joined the law? So your attitude is going to be changed when you have that is going to study the law. So here earlier when you used to go to a market and want to buy something, whether you have thought it that no, it is a contract. So there is an offer, there is an acceptance, there is a consideration, everything is there. But even though that all the transaction has been done legally, but it is without your knowledge. Under the Sale of Goods Act, so here when the property in the goods is going to be transferred from one person to another person, under the Sale of Goods Act. Are you aware of this fact? Earlier, before joining the law? No. Why? Because that particular distinction, that is the minor, distinguishing factors also which are there that you have not, noticed all these things. So here, if you quote an illustration in this particular behalf, if you go to a grocery shop, and you want to ask, or you offer, no, I want to buy 5 kgs of sugar. So here you have paid the amount also. So he is packing it. Another friend of you comes, no, that today in CMRU, that is Law College, no, that the guest lecture is there. So already it is 9, it starts at 9:30, that I want to go and have a cup of tea. So that you give 5, kgs of sugar. He takes away and goes. So whether the property goes along with him or it remains with you, until and unless that delivery is there, so property will be owner, and so till then, so it cannot be transferred. So in this way, so here this awareness of the legal awareness, so it comes only one, so that it is given. So here, there are so many cases wherein that is trafficking will be there. That is women trafficking, child trafficking and other trafficking, and women harassments will be there. So here dowry harassments will be there. So here you are all that is holding the camps to give this awareness. So many a times that what happens is, so here that a woman who is that is there in a house, so here she will be tolerating whatever the harassment which is going to be given by the in-laws, only because that she is not knowing what are their rights, how that she can protect herself, where she can go, where the complaint has to be filed. Even now that special, that is a police stations have been formed for the purpose of recording this dowry, that is harassment cases are concerned. And even many a times nobody will be knowing if a woman is arrested. If a woman is arrested, who can arrest? There are guidelines. Even in spite of guidelines, that what we are saying in the court is, so here a woman will be brought from Bijapur to Bangalore by a male police constable. Why it happens? Because she is not knowing that she should be accompanied by a that is a woman police. So in that light, so this awareness which is going to be given, so it plays a very important role. So here, if awareness is given, definitely, so here that you can protect, or that woman can protect her rights. So in the, that is, these are all the ways, so in which, so here the Legal Services Authority, so it helps. So here, one more aspect that which I want to say in this particular behalf itself is, so earlier, Lok Adalat used to be held only the cases of motor vehicle accident cases used to be used to be sent to this Lok Adalat, and they used to be negotiated and they used to be settled. Nowadays you are seeing all types of cases. All types of cases after this section 89 of CPC. So here it is mandatory. The word used in section 89 is it shall. So here before that you that is go on for the trial. So here you must that is think on that whether any that is of this four, that is whether it has to be sent for Legal Services Authority or mediation, arbitration, conciliation and other, that's it. In IFCON's case, it has been specifically stated what are the types of the cases which can be referred and which cannot be referred. You take for instance a suit for that is declaring these elections and so counting and other things are there. So it cannot be that is settled in a mediation or a Lok Adalat. No. I will be 2.5 years. CM, you will be 2.5 years. Okay, we can settle like this. Can it be done? No. So this awareness that it is going to be given is only by Legal Services Authority. Nowhere that we can get all these informations. So in that light, so here the asserting their rights and in respect of the matter of right, not as a favor. So here whenever right is there, it is not a favor. Sometimes people will think, no, the government is going to providing us, so here flood relief. So it is a favor for us. No, it is not a favor. It is a right which is entitled to be given by the government. So in that light, so here these are some of these particularly the aspects that which we have to keep in mind. So whenever that we want to, that is, go through this Legal Services Authorities. My friends, nowadays, so here a new concept has been also started now. Earlier, whatever the type of cases which were pending before the court, they used to be referred for the purpose of settlement in the Lok Adalat. Now, there are two categories so which have been made. So here, post, that is pre-litigation services and post-litigation services. So here, what you mean by this particularly, the pre-litigation services, even, so here, the pre-litigation litigation cases can also be brought before the Lok Adalat and they can be settled. Are you aware of this? So you take for instance, a dispute has arisen that it has not approached the court of law. Two parties are fighting for, that is, partition of a property, brothers. It has not approached the court of law. So even then, both the parties can refer it to this particularly the legal services authority, and it can be adjudicated in the legal services authorities and settle the matter, and whatever the settlement so which is going to be arrived is considered to be a legal settlement. It is called as pre-litigation. Pre-litigation cases. Many cases that as you are also aware of, that small loans which are going to be given by the banks. Nowadays, small loans are also that is going to be given. So yes, they do not want to go to court of law. They say, no, amicably we can go to the legal services authority and settle. So what is the importance of this? So it will reduce the cost of litigation. Cost of litigation. If it goes to the court of law, so here you have to engage a counsel, you have to pay the court fees and other things. If a bank wants to recover rupees 10,000, so here 10% that court fee has to be paid, and some, that is a litigation charge to the advocate, some expenses have to be paid for the purpose of typing, copying and other things, serving the notice. So here, if you settle before this particularly the litigation cases, all this cost is going to be reduced. It is not included in the cost. So here people will feel, no, that it is better. What happens is, in case of this particularly the bank loans, so taking of the loan or accepting of the loan is not going to be denied by any parties, because all the documentation will be there. ನಾವು ಹೇಳ್ತೀವಲ್ಲ ಏನಂತ, ಬ್ಯಾಂಕಿಗೆ ಹೋಗಿ ಲೋನ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ ನೀವು ಅವ್ರು ಬೇಕಾದ್ರೆ 100 ಪೇಜ್ ಇಟ್ಟರು ಬಡ ಸಹಿ ಮಾಡಿಬಿಡ್ತೀವಿ ನಾವು, ಅಲ್ಲ, ಇನ್ಕ್ಲೂಡಿಂಗ್ ಮೀ ಐ ಆಮ್ ಟೆಲಿಂಗ್. We will not see terms and conditions. I think you are all having vehicles. Almost all you are having your vehicles. You insure your vehicle, isn't it? You insure your vehicle for various reasons. So how many of us or you have that is gone through the conditions so which are there on the backside of the policy? That is one. Even if you want to read it, it is very difficult to read it. It is in such a small, that is, words. So in that light, so here that you cannot, that is, deny all those things. So then under such circumstances, the best way is to settle this matter before the, that is the Lok Adalat. So here, the post-legal services that I do not want to, that is, go in there in this particular regard, that you are aware of that. So here, another aspect is, so here legal education, legal advisors and legal awareness. If you go to this particularly Article 22, so there also it says, no, if a particular person has to be arrested by a police, there are certain conditions. What are those conditions? So here, the grounds of the arrest must be made known to this particularly the person who is going to be apprehended. Isn't it? Under the legal services authority, whenever you go to this particularly awareness, awareness program. So here you have to, that is, give this particular information. If a woman has to be searched, she must be searched in front of a woman or a woman constable, or by a woman constable. And whenever a particular person has been apprehended, within 24 hours he has to be produced before the nearest magistrate. These aspects are not known to many persons. Many persons. The police will come and he takes to the police station and keeps him, ask him to sit on the desk or desk. He will be there. He will show the arrest or apprehension as and when he feels free, and then whenever he wants to produce before the court. So in that regard, so here if you see Article 22 and 20 and this legal services authorities, so here much importance has been given to that these aspects. So here one more that's a thing, so which I want to, that is tell in at this juncture is, who is entitled to legal services? Who is entitled? Who is entitled? So here, first, persons belonging to scheduled caste and scheduled tribes, they are entitled. The second one is woman or a child. So here, whatever may be her income, only as an illustration I am telling, Adani's wife or Ambani's wife. So if she wants to take a legal assistance, so here she can write, no doubt that they will not come here. So here that she can write, no, I want a legal assistance. So the legal assistance has to be provided. And victims of trafficking, so whenever a woman trafficking is there, child trafficking is there, or a, that is small kids, so then under such circumstances also, so here that legal services are there is concerned. And the fourth one is mentally ill or disabled persons. So here the third one is the under special circumstances and the persons who are in custody. So here, if a particular person is in custody, if he is unable to take the legal assistance, so here of his choice, then under such circumstances, so here he can ask for the legal services authority to provide. So here there are some procedures so which have to be followed. So here he has to make a request, and some committees are there. That committee is going to approve all these things, and a advocate is going to be appointed, and he will look after that. So here whenever the legal services authority takes the cases, no court fee has to be paid. No payment of the court fee is there. So you must, that is, make this particular aspect very clear. So here, after this, particularly the legal services, nowadays in all the colleges, paralegal volunteers have been also, that is, I think, appointed, paralegal volunteers. So what is their duties? I think paralegal volunteers are yes. So here they are also, that is, contributing so much for the purpose of, that is, giving awareness and legal aid or legal clinic, and even that in various universities. So here practical legal assistance is going to be given for the purpose of this, particularly the legal services authority is concerned. So here, if you take the object behind this, particularly the legal services authority, is only to reduce the court backlog. There is a docket explosion and so many cases are pending. In one case, I will tell you, it so happened a summons has been or a notice has been served to a party. A summons has been served or a notice has been served to the party. He came to the court. He can personally appear in the court also, that you are aware of the fact. He can conduct himself the case. There is no necessity that he should engage the counsel, and so here only the counsel can conduct the case. That is not the law. So the parties, they themselves can conduct the case. But in that case, what happened is, so here he gave an application. Give time for engaging a counsel. So what he has written is, so engaging a suitable counsel. The word used is suitable counsel. The judge who was presiding over the court, he said, no, so many advocates are sitting in the court that you can engage in any one of them. Why you want time? So then he said, so here I want to engage a suitable advocate. Suitable in the sense what? That question arose before the court. Suitable means what? Suitability is, it differs from person to person. So he may be seeing intelligence. So he may be seeing economical aspect, that whether he is afford to pay. So here whatever the fees which is going to be asked by that, and his experience, and whether that he is competent to engage that type of case. Nowadays the specialization is there. Earlier that every case used to be dealt by every advocate. Nowadays, so here that after this digitalization and other things, specializations that is started now. In medical field, specialization is there. So here, if you go to this particularly, so here one person, after seeing your body, he says, no, that this particular checkup has to be done by that particular person, physician, and the persons so who are there in this particular job. If you want to check up with the eye, so in that eye itself, there are specializations in this particular regard. So here, in the same fashion, in legal field also, so here, if a particular person is dealing with civil cases, so if you entrust a criminal case, so it is very bad. He may not be in a position to conduct the case. Vice versa is also there. So in that light, so in that case, judge passed an order. So it came up before the High Court. Then High Court upheld the contention taken up by the party. So here, suitability is with reference to the context of that particular person. It is not the judge who can decide it. Suitability. So in that light, so here merely because that a legal services authority is there, so here that this particular that the person can be appointed, it is not. In many cases, that what we are seeing is, so from legal services authority, whoever is going to be appointed, so here they will not take much care with regard to those cases which have been entrusted through legal services authorities. If it is a private case, so here they will take so much interest because, so here under the that is Consumer Protection Act also that it comes, deficiency of service, if it is there, he can sue for that. So in that light, so here that this particularly the person suitability, so it has to be seen in the particular regard. So here, one more, that's the thing. Ultimately, what is the aim of this particularly the judicial system is to do justice. So here, you are aware of, in the constitution also it says, audi alteram partem. So no man can be condemned unheard So if a man has to be, that is, dealt with in fashion, so here that he should be given an opportunity. There are so many cases. In many criminal cases that the Supreme Court has also said, no, the accused can keep himself silent. He cannot disclose his defense. It is the duty of the prosecution to establish. It is the duty of the prosecution to establish. Until and unless the prosecution establishes the case, so here accused cannot be convicted. He cannot say nothing, even if he denies it, okay, that's all. So in that light, so here that to improve the quality of, that is, justice, and to protect, that is, the principles of ordi alteram partem, the legal services authority helps. Wherein a particular person who is not capable of giving any advocate, the court can appoint, especially in cases of custody. Court can appoint, and so here that he must be represented by an advocate so as to properly conduct the case and to come to a proper conclusion. In murder cases, even murder cases that you know under the CRPC and now that the BNSS Act and other acts. So here there are 3 cases. Whenever a charge sheet has been filed, the court has to take the cognizance and issue the summons after appearance of the accused. So here that in the first instance the court can ask whether that he wants to plead guilty. In petty cases, many a times if he pleads guilty, a minor penalty is going to be imposed and that he is going to be convicted. But in murder cases, it is said by the Supreme Court, even if he pleads guilty, that it is the duty of the court to verify and come to a proper conclusion that whether it is voluntary or not, and if it is not satisfied, so it can post it for the purpose of trial. It has to be tried in accordance with law. So in that light also, so here that is particularly the legal services authority helps. So even in spite of lot of development in the legal services authorities, still there are flaws. Still there are flaws. The pendency has not been reduced as on date. No, ADR systems are there. And in every Lok Adalat we say 15 lakhs cases have been settled. But still that is particularly the pendency of, that is backlog is there in this particular regard. And the second that is a flaw which is there, that we just I have referred it is, so here that legal aid advocates, so whose assistance is going to be given, it is not satisfactory. It is not satisfactory. They are not doing properly work. There are various reasons for that. Whatever the remuneration which is going to be paid by the legal services authority is very meager. ನೀವು ಹೊರಗಡೆ ಅಡ್ವೊಕೇಟ್ ಹೋಗಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದರೆ ಒಂದು ಬೇಲ್ ಅಪ್ಲಿಕೇಶನ್ಗೆ ₹1,00,000 ತಗೊಂತಾರೆ ಬೆಂಗಳೂರಲ್ಲಿ. ಇಲ್ಲಿ ₹3,000 ಕೊಡ್ತಾರೆ. ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಅಥಾರಿಟಿಯಿಂದ ಒಂದು ಕೇಸನ್ನು ಇದು ಮಾಡಿದ್ರೆ ₹3,000 ಕೊಡ್ತಾರೆ. How much interest that a particular advocate will give to that particular case? That is one issue. The second is, so here many that is intelligent and senior advocates, they will not come forward to be in the panel of this particularly the legal services authorities. ಅವರೇ ನಮಗೆ ಸಾಕಷ್ಟು ಕೇಸಸ್ ಇದೆ ರೀ, ಅದಕ್ಕೆ ಎಲ್ಲಿ ಮತ್ತೆ ಮಾಡೋದು ಅಂತ. Even if they come because of some obligation a judge has called and so here they want to be in good books, so they say no, I will be in penal. So here they will send the juniors to the legal services cases. again there will not be proper representation. So ultimately, the purpose for which the Legal Services Authority or Legal Services Act has been passed, so here it has not satisfied to the extent which was expected. There are so many other, that is authorities are there at a national level, state level and district level, taluka level. So various, that is the clinics are that, and district legal services authority and other, they are there. But in spite of that, so here that the work which is, that is discharged, it is not satisfactory to the expectation. So something has to be done. So what has to be done? How that this particularly the institution has to be improved? It is in your hand. You have to extract where are the flaws, how that you can improve. So here, whenever that you buy a motorbike, so you start thinking then what? How to increase the consumption, petrol consumption, and how to ride it. In that fashion, that this is also one of the things, so wherein that you can, that is, look into this aspect. And one more that aspect is, so whenever that this particularly legal aid is given in the prison, so here that it is also not satisfactory. These are some of the flaws that wherein that we can look into this aspect, and you can give some solutions to that. I think that many a times you are that is in your curriculum. So here that jail visit may be there. Jail visit may be there. So here there that the legal assistance is very much required. Very much it is required, because many people that they are not aware of, they are entitled for a legal assistance. And even word that is CRPC, that 107 and 109 says, so immediately after that the accused appears, copies of all the documents are to be furnished to him to know what is the case. That if you are not aware of what type of question on what subject that the questions are going to come before your exam, are you able to answer it? In the same fashion, if accused is not knowing what is his case, how can he defend himself? So these are some of the aspects that that you have to keep in mind whenever that you go to this particularly the legal aid cells or a clinic and that awareness programs. So here then you must disperse all this knowledge. Know that today's program, that is today's lecture is, so here that recent developments, lot of development every day, that there are some, that is the developments in the legal services authority is there, but it is not satisfactory to the expectation. Nowadays, you see, if you score 90, by saying it is good, but if you think otherwise, so why you have got a 10 marks less, there is a chance for improvement again. There is a chance for improvement. If you say, no, I have, that is got first class, first 90, no, nobody is above me. That is different, that you are satisfied, yes, I am the top in the class. But if you think reverse, no, why I got 10 marks less? Where is my defect? How that the defect has happened? Where the defect has happened? So in that light, that the legal services authority, if you say that is so many that the developments are taken place within, that is 10 to 15 years. Sometimes that we comment in almost all the fields that the legal services are doing the work. If a road accident happens, there also it comes. If a flood comes, it also comes. Famine, it also comes. Everywhere it comes. Something happens in that is general public. So here that somebody says no, what the legal services authority is doing for that. Even some public interest litigations have been also filed by the legal services authorities. Public interest litigations to protect the interest of the general public. Very recently, that you are aware of the fact that in Chamarajanagar, the 39 COVID deaths happened because of a lack of oxygen. So a PIL has been filed to investigate and do that is justice in that light. So Hon'ble I got appointed two committees, one from the legal services authorities, one by me. So it also give the report and I also give the report, but nothing has happened as on date. So in that light, so what I want to say is, so whatever the services which are that is going to be provided, so here that it should be provided to see that it is satisfied. That's why it is said, we are planning very well. In all aspects that we plan very well. So here you take for instance, within 3 months, 4 months that the examinations are going to appear. You prepare a timetable. Morning 6 o'clock, get up. 15 minutes, fresh up. Go for a small walk. Come, have a cup of coffee. Then 2 hours that continuously study one subject. Then take a break, have a breakfast. Then study 1 hour. Then take 15 minutes rest. And thereafter that is go for lunch. So that is prepare, that is timetable. Timetable is ready. But you must act in accordance with timetable. Then only then you will. That's why it is said. So many people will do many things, but some people will succeed only because they plan well and they execute it well. Until and unless you execute it properly, so here that it will not be. Okay, nowadays that is just a 2020, that is a cricket match is going on now. Now here, no. ಸ್ವಲ್ಪ ಮುಂದೆ ಸರಿದು ಅವ್ನು ಕ್ಯಾಚ್ ಹಿಡಿದು ಬಿಟ್ಟಿದ್ರೆ ಕ್ಲಾಸ್ ಮ್ಯಾಚ್ ಟರ್ನ್ ಆಗಿ ಹೋಗ್ಬಿಟ್ಟಿತ್ತು. If you are on that place, even you could not have fought the ball up. It is very difficult to sit in a chair and so here give lectures. You ought to have done this, you ought to have been done. ಅದಕ್ಕೆ ಮನೆಯಾಗ ನೋಡ್ರಿ ಸಣ್ಣ ಹುಡುಗರು ಇದ್ರಂದ್ರೆ ನಾನು ಓದು ಮುಂದೆ ಹೆಂಗ್ ಓದ್ತಿದ್ದೆ ಗೊತ್ತೈತೇನೋ ಅಂತ. ಅದಕ್ಕೆ ಒಂದ್ಸರಿ ಏನಾಗ್ತದೆ ಅಂತಂದ್ರೆ ಮಗಗೆ ಬೈತಾ ಇರ್ತಾನೆ ನಾನು ಓದೋ ಮುಂದೆ ಹೆಂಗೆ ಮಾಡ್ತಿದ್ದೆ ಗೊತ್ತೈತಾನೆ 100ಕ್ಕೆ 100 ಅಂತಂದು ಹೇಳ್ತಾನೆ. ಮಗ ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ತಂದ್ಬಿಟ್ಟಿರ್ತಾನೆ. ಇಲ್ಲಿದೆಯಪ್ಪ ನಂದು ನಿನ್ನ ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ನೋಡಿದ್ದೀನಿ ಎಲ್ಲ 35 ಅಲ್ಲ ಅಂದ್ರೆ that's how. So if you want to tell something to somebody, you must also be perfect and everything. To you all for having spared your valuable time and given your time to me. Thank you. Good day.